and welcome to all of you to our SIEL panel on Building Back Greener, Rethinking Investment Protection to Feed the European Green Deal. My name is Ilaria Espa, and I am a Senior Assistant Professor of International Economic Law at USI Lugano and a Senior Research Fellow at the World Trade Institute in Bern. I have the distinct pleasure to be moderating this panel today. The theme of this session could not be more topical as this
Ilaria?
Oh dear, Matteo, I think you will need to sort of step in.
I think I will need to step in, right? That happened before. We hoped it did not happen again, but I'm confident that Ilaria will come back in a few seconds, as happened before. Of course, it is my pleasure on behalf also of Professor Espa, who will come back in a minute, to welcome you to this panel, which was also co-organized by Dr. Alessandro Monti, postdoc at the University of Copenhagen at the Center for International Law and Governance, and myself as Assistant Professor of International European Environmental Law at the University of Hasselt in Belgium. Well, let me say that the core topic of this panel is quite, to some extent, self-explanatory. I wanted to frame the current situation which is going on in the European Union with regard to the, let's say, unprecedented developments in relation to the European Green Deal. The European Green Deal is an encompassing array of policies. Basically, it's a kind of black box where the EU established European Commission would like to foster its ambition towards carbon neutrality, towards environmental protection, but also to foster investments, also from, of course, a foreign direct investment perspective in order to achieve its long-term objectives. There is an important foreign investment law dimension within and outside, to some extent, the European Green Deal, which we wanted to unfold today. And hence also the selection of the topics which will be addressed in this panel, and also the selection of the speakers who are, I assume, very much high level, and I wish to thank all of them for joining us today. Just to recap the rules of the game, still waiting for Ilaria to come back in. We wanted, of course, this panel to be as interactive as possible. So I will try by replacing Ilaria to have maximum 8-minute talk for each speaker first, with PowerPoint presentation, if any. And afterwards, we will have a round of questions, which will be follow-up question to the previous presentation, maximum 5 minutes answer for each question. And afterwards, of course, we will open up the floor for audience questions. Of course, each and every participant is free and is warmly welcome to put her or his questions in the chat, which every speaker and myself, on behalf of Ilaria, will try to address. But I will not take further time out of the discussion. And I will then turn, if Ilaria is not back in, but I assume not, I will just leave the screen to Alessandro, so to Alessandro Monti, who, as I mentioned, is postdoc at the University of Copenhagen. He is presenting to some extent also on my behalf, because we are doing some work together. So Alessandro, please, the screen is totally yours. In the meantime, I will just lift up the red card as a 2-minute warning. Please.
Thank you, Matteo, for the kind introduction. And I will now try to share my screen, hopefully without any issues. Yes, can you all see my slides? Okay, perfect. Then I will start. So thanks again for the introduction, Matteo, and well, to Ilaria, who we hope will join us back soon. And it is my pleasure to present today the paper on which Matteo and I, Matteo Fermeglia, assistant professor at Hasselt University, and myself are working on, and it addresses the latest development in the interaction between EU investment and climate law. So focusing on the Energy Charter Treaty to some extent, but also connecting the dots with some other developments concerning, on one hand, the termination of intra-EU bilateral investment treaties, and on the other hand, also the broader policy discourse around the European Green Deal. And starting from the termination agreement, so this is an agreement which has been signed in May 2020 by the vast majority of EU member states, 23 of them, with just few exceptions, and it terminates approximately 130 intra-EU bilateral investment treaties. So this agreement essentially responds to the judgment by the European Court of Justice in the Achmea case in 2018, in which it was ruled that intra-EU investment arbitration is not compatible with the principle of primacy of EU law, and in particular with Articles 267 and 344 of the TFEU. However, the actual implications for climate change of both the Achmea judgment and specifically the termination agreement may seem rather limited. And this is because the termination agreement does not address one of the major sources of litigation that is climate relevant, which is the disputes raised under the Energy Charter Treaty. Instead, the termination agreement only terminates bilateral investment agreements and explicitly excludes the Energy Charter Treaty from its scope of application. So one could think, at least prima facie, that the termination agreement is rather irrelevant for climate purposes. However, it's also important to look at a number of recent developments concerning litigation and arbitration under the Energy Charter Treaty. And first of all, after the Achmea case, respondent host states have often raised jurisdictional issues in arbitration under the Energy Charter Treaty. And however, the tribunals have largely rejected member states' objections to their jurisdiction and allowed the cases to go through anyway. And indeed, this is also related to the fact that the Achmea judgment did not explicitly address the Energy Charter Treaty, but only bilateral investment treaties. But in the latest months, very recently, in the last 6 months, I would say from December 2020, when the government of Belgium asked the Court of Justice of the European Union for an advisory opinion on the compatibility of the draft Article 26 of the modernized version of the Energy Charter Treaty, which would also foresee arbitration as a means of dispute settlement for the compatibility of this with the treaties. And even more recently, in a case between Italy and the Danish investor Athena, which was being adjudicated before the SVIA Court of Appeal, it was a case for annulment of an award which has been rendered in favor of the investor and against Italy in one of the renewable energy disputes. The Italian government has raised the issue that this kind of arbitration under the Energy Charter Treaty in an intra-EU case is not compatible with the treaties. And the Swedish Court of Svea decided to request a preliminary ruling to the European Court of Justice. And similarly, and somehow also differently, the issue of the Energy Charter Treaty in intra-EU disputes has also been raised by Advocate General Spunar in the case Moldova-Comstre, which is in itself a purely extra-EU case, but it gave the opportunity to the Advocate General to underline that allowing investment arbitration under the Energy Charter Treaty in intra-EU cases is not compatible with the treaties. The later case was, however, only concerning the question of that specific dispute outside the EU, and therefore it is quite unlikely that the Court of Justice will actually rule on the merits of the compatibility of Article 26 and the treaties. But differently in the Italy versus Athena case, there are good possibilities for the Court of Justice to make clarity on whether or not the Energy Charter Treaty and the Article 26 arbitration mechanisms are compatible with EU law. And so coming to a conclusion and making a possible link with the the termination agreement. In fact, it's possible to argue, and we would like to explore to what extent this can happen, that the Court of Justice of the European Union would somehow fill the gaps that are left by the termination agreement with respect to the Energy Charter Treaty, because it is true on one hand that with the opinion 117, the European Court of Justice has affirmed that ISDS in itself is not incompatible with EU law when it is conducted with third countries and not intra-EU. And indeed, this was also one of the reasons why the termination agreement could not address the Energy Charter Treaty, is that the Energy Charter Treaty is also a treaty with third countries, the EU as a party to the treaty itself, so it's not a purely bilateral agreement. But a potential solution which the European Court of Justice could adopt, also taking into account the termination agreement, would be to exclude the applicability of ISDS provisions under the Energy Charter Treaty only in intra-EU disputes, while still allowing this to happen with non-EU states. This could have potential impacts in terms of pending and future arbitrations. They may be rather limited because I've seen the arbitration tribunals don't like to accept that they don't have jurisdiction, let's say, but it could be relevant again when requesting the annulment of arbitral awards before domestic courts in the EU. And this can happen in cases adjudicated under the UNCITRAL or the SEC, Stockholm Chamber of Commerce rules, and not indeed in ICSID cases, which do not follow this kind of procedure. And again, it could become relevant when states challenge the enforceability of awards before domestic courts. So these are some of the potential implications. And indeed, one could remain with the question that then the legal framework for investors would dramatically change, and it could have negative implications in terms of regulatory stability and predictability. However, we argue that the overall policy framework, which has been developed within the European Green Deal, allows, with the various instruments, to take into account also this and somehow develop a new notion of regulatory stability and predictability for EU investors. Now, I've seen the red card, so I assume my time is over, and I will give the word back to either Matteo or Ilaria. Thank you so much.
Thank you so much, Alessandro, and apologies indeed. I must have had a connection problem, but now I'm fully back. And I thank Alessandro for his very interesting presentation. I'd like to follow up right away with a question in keeping with the format of the panel. Matteo kindly explained while I was out. And I'd like to ask you, considering that the European Green Deal encompasses a broad range of measures which are of direct relevance to climate-related investments, especially when it comes to the energy sector, how could or should this framework affect the prospects of pending and future intra-EU ISDS litigation, as we do seek for more regulatory coherence on the side of investment regulation within the EU and outside the EU?
Thank you for your question. And I think perhaps Matteo would like to answer on this specific point.
Well, yeah, I can take over on that. Thanks, Alessandro, also for your presentation as an interim moderator. Well, the question is, of course, well pointed, as Alessandro kind of put on the table. We believe that despite all the efforts of the Commission to really make sure that foreign investment protection does not undermine the uptake of ambitious policies, especially with regard to renewable energy generation, but also with regard to the true energy transition. Think of what's going on in the Netherlands right now, what's been going on also in Germany. We know all about these cases, right? Our point is also that looking deep into the implementing acts that came before the European Green Deal and that will come after, or very much soon, I think, also with the Fit for 55 package, which will further implement the European Green Deal, there are already a lot of scattered references, quite clear, to the need to ensure regulatory stability. Of course, we know that from the perspective of EU primary law, a lot of competencies and ultimately the choice as to how to foster different energy sources in the energy mix is left up to the member states. So there is always some room, some leeway for uncertainty as regards what the member states could do ultimately, and this is what has happened with the feed-in tariffs in Spain and Italy. However, we could definitely see that some regulation, and I'm referring more specifically definitely to the governance regulation of the Energy Union, which was enacted in 2018 and is now really being given teeth, is aimed specifically, and you can find several references both in the recitals and also throughout the text of the regulation, to ensure long-term stability, long-term predictability of energy policies of the member states. According to the energy regulation, of course, every member state should come up with an integrated national energy and climate plan. In these plans, which will be assessed regularly every 5 years by the European Commission, these plans are not kind of black letter documents that are kind of very vague and kind of only set the trajectory for long or medium to long-term commitments, but also include specific measures that have to be taken to address and to achieve the targets that are set in the same plans in order, of course, to contribute to the overall target of the European Union. And there you could definitely find both some monitoring and enforcement powers to the European Commission, in charge of the European Commission in case of, in case the state do not deliver on what it has promised to do, and also some very much specificity about the measures that member states have to take, especially with regard to renewable energy generation. This is also backed by Article 6 of the Renewable Energy Directive, the new Renewable Energy Directive, which will be revised in 10 days or even less, which specifically mandates member states not to undertake retrospective changes to support schemes for renewable energy. This is pretty much tailor-made to address and, of course, to avoid ISDS disputes. This has been very much contested as a specific, let's say, solution to the problem, as it kind of somehow leaves very, very, very little room to member states in how to operate. But of course, it is directly channeled to ensure stability in this regard. But there are a lot of other, let's say, norms or a lot of references throughout several other pieces of legislation. Of course, the EU climate law, the very last one, which has just been approved, by posing collective trajectories for 2030 and for ideally to 2050, will definitely ensure long-term predictability of EU and also of member states' energy policies, both with regard to fossil fuels infrastructure and also to renewable energy infrastructures. And last, of course, why I want to mention the EU screening regulation. The EU screening regulation is related to specific strategic investments, of course, but it gives, at least in theory, quite a lot of powers, or let's say oversight powers for the EU Commission to make sure that, of course, specific investments coming from abroad, from outside the EU, will not undermine strategic assets. And last, I think also the EU taxonomy is relevant in this regard. The EU taxonomy really explains in quite a detailed way what kind of investments, according to the European Commission, are deemed as sustainable and contributing to the European Green Deal. I will not go into the detail, but from the perspective of a foreign investor, this patchwork of instruments, and there will be others coming up soon, will definitely provide quite a picture of what within the European Union is deemed as an investment that could, let's say, withstand the development of the regulatory framework in the long term. There are a lot of other things to be said, of course, so it's hard to wrap up in 5 minutes. But my point is that with this regulatory, let's say, setup in place, in ISDS disputes, not the pending ISDS disputes, but perhaps future ISDS disputes, there will be quite a lot of shift on the due diligence of investors, which has already been addressed in some renewable energy disputes. But I think now the European internal regulatory framework is not fit for purpose to really provide a stable, let's say, and more investor-friendly environment as the Green Deal moves forward. So thank you for your question, Ilaria. I hope I have exceeded my time.
You were perfect. Thank you so much, Matteo. And indeed, lots of food for thought. I see there are already some public chat questions that we are looking forward to go to. But now let's move to the second speaker, who is Krina Baltag. Krina is a senior lecturer in international arbitration at Stockholm University, is also the co-director of its Master in International Commercial Arbitration Law, and her contribution will focus on the modernization process of the Energy Charter Treaty and the prospects for climate proofing it. Krina, you have the floor for 8 minutes. Thank you.
Thank you very much, Ilaria, and thank you to the organizers and to my colleagues for this already very interesting discussion. And I know that we are starting to focus a bit more on the Energy Charter Treaty and its modernization process, and Alessandro was alluding to some of the aspects and probably how it will be dealt with the Achmea issue. One point that has to be highlighted is that the process is not at all transparent. Only what leaks to the public, as it was the other day, as we're currently now in a session of the modernization group, we hear from time to time if there's a consensus or not on certain points. But we do have, from December last year, a paper of discussion of the Energy Charter Treaty Modernization Group, which highlights some of the provisions that more or less have a common ground of discussion before the contracting parties to the ECT. And in light of the topic of our panel today, obviously, I would like to be more concerned with the right to regulate of the contracting parties, and obviously with sustainable development. And I would start by saying that the Energy Charter Treaty, as we know, has entered into force in 1998, a completely different landscape at that point. That is to say, the modernization process should not be perceived as something negative. Of course, there are several practical aspects raised in the investment arbitration disputes, which probably contracting parties would like to see them differently approach in a new Energy Charter Treaty. But as any treaty in the field, irrespective that deals specifically with energy investments or with investments in general, it's an evolving treaty. And it should be this way because we live in a different reality at this point. So we have other points of concern, as mentioned by Matteo. We are moving from investment regulation, from investment promotion protection to investment regulation. And therefore, treaties should reflect this approach accordingly. So with this, we have to bear in mind that also the modernization process has to be viewed in the light of the treaty and the fact that the contracting parties will have to unanimously agree on any amendments to the treaty. So there are several hurdles, but at the same time, as I said, this should not be perceived as a negative aspect of the Energy Charter Treaty. However, what you see in the newspapers, and this is partly fueled by the lack of transparency of the modernization process, you can read every day headlines in the press such as multi-billion-euro lawsuits derail climate action. EU urged to quit energy treaty as companies sue over climate action. Europe's Green Deal is under threat from the Energy Charter Treaty. So we do have this strong public opinion surrounding the process. And of course, as mentioned before, we are now adding to this the 2019 EU Clean Energy Package, which sets ambitious goals. By 2030, which is around the corner, there has to be 40% cuts in greenhouse gas emissions. That's quite a lot, especially when you consider that some of the technologies are not yet fully developed. And at least 30% renewables in energy consumption. Again, another challenge that we have to face. At the same time, we have other developments outside the European Union, such as the Fossil Fuel Non-Proliferation Treaty, which is endorsed currently by numerous cities, subnational governments, and of course, different organizations. And to this, at least for the investment arbitration and investment law practitioners and investors, we have the investor state reform, which is currently underway in the UNCITRAL Working Group 3, and suspected to conclude in 2026, so sometime from now. So we have a ticking bomb, I would say, and the Energy Charter Treaty has to deal with all these elements. And I would highlight as well the fact that the Energy Charter Treaty, although from 1998, it has sufficient elements in it to say, or to safely conclude that at that time at least, it was a modern treaty. It has Article 19, which deals with environmental issues and which recognizes the obligations under international agreements concluded by the contracting parties. Of course, this single provision is not sufficient. As well, it has the provision on the exceptions to the protection and promotion of foreign investments. And those exceptions, of course, where the contracting parties, they have to make a decision which comes to safeguard public interest and to protect societal interests such as environment and health, and has to breach some of the provisions of the Energy Charter Treaty. But that is to say, it is not enough. So this is why you have a modernization process. As I said, it's not a negative issue. Other treaties are undertaking the same process. The model BITs that we see, bilateral investment treaties, including the Dutch model BIT, the 2021 Canadian FIPA, the model BIT, and so on, they're all reflecting these new trends. That is, spelled out the right of the state to regulate, most foremost, and also the right to sustainable development. And with this, in the Energy Charter Treaty process, modernization process, we have important proposals put on the table. The first one, in addition to the exceptions provision, we have the right to regulate, obviously, which addresses particularly the cases of the renewable energy disputes. And those are not few. As we know, at least 54 cases against Spain, adding to that about 12 or more cases against Italy. I would say a total of over 65 cases concerning renewable energy, and all dealing with the right of the state to regulate and to adopt certain laws and regulations. So this proposal comes to address this very concern of the contracting parties to the Energy Charter Treaty. On the sustainable development, very important provisions. And these are not, again, new provisions. The fact that the state should not lower the standards, contracting parties to the Energy Charter Treaty should keep their standards, including those concerning environmental protection, both the measures adopted concerning the climate change, and should not lower the standards in order to attract investments. At the same time, the contracting parties shall effectively implement the international commitments, and this includes the Paris Agreement. Also, the contracting parties should recognize the value of the international agreements when dealing with investments and their protection. So there are very important aspects which are being addressed. Now, I want to stress out from the perspective of an arbitration practitioner, in particular investment arbitration practitioner, that the right to regulate is not absolute. And this is something that is not specifically addressed in this proposal, in this proposed provisions of the new Energy Charter Treaty. We know that the right of the state to regulate has to meet certain conditions, such as the regulation has to be taken within the public interest of the state in good faith. The measure has to be proportional with the purposes, and it should not be discriminatory. And these are elements that in practice are addressed and assessed by the arbitral tribunals. So even a contracting party to the Energy Charter Treaty will take a measure within the right to regulate. Still, a tribunal will have to look at these elements to determine if there is or not a breach of the Energy Charter Treaty and whether it's taken within this right to regulate. Now, on the last point related to the right to regulate and sustainable development, and why those titles in the press and obviously a lot of pressure put on the Energy Charter Treaty, and including on the EU and EU member states to leave the Energy Charter Treaty, is the fact that the protection is on the energy materials as investments as defined by the Energy Charter Treaty. And there are several points here. The first one, obviously, for a treaty adopted in 1998, we have different types of energy materials currently, which should be included in this definition, and the European Union came up with a proposal. And the second problem is, how do you ensure the transfer to clean energy and for the European Union to achieve these goals when the Energy Charter Treaty contains provisions on the fair and equitable treatment, expropriation, and so on. And you have to, as a contracting party, literally terminate these fossil fuel energy investments. And this is the new cases that Matteo was mentioning earlier. So the European Union proposal is literally to have a phasing out, not to protect these investments concerning the fossil fuel energy. And this is where the real problem starts, because the Energy Charter Treaty is a multilateral treaty, and some important states, especially those coming from Central Asia, are the ones where the fossil fuel energy is the most important. So there is a strong, strong opposition at the table, at least in this respect. Thank you very much, Ilaria.
Thank you so much, Karina, for giving us an overview of what's going on and the most controversial issues there. Now, just a follow-up question very briefly, because we all know that the EU is heavily invested in the modernization process, also due to the developments that were earlier mentioned by Alessandro and Matteo. So I just wanted to ask you in this respect whether, considering that, of course, reforming the ECT in the direction that's envisaged by the EU and the European Green Deal would arguably contribute to climate proofing it, do you think there is a risk of this process as being perceived as too EU-centric? And if so, do you see any dangers in exporting the EU model into this modernization process?
This is a very interesting question, and I would start by saying that all the contracting parties to the Energy Charter Treaty, except for one, which is Turkey, have ratified the Paris Agreement. Turkey has signed, but it's yet to ratify it. So I would say that the concerns, at least when it comes to climate change, environmental protection, are common to all of the contracting parties. If we look back at how the Energy Charter Treaty was drafted, it was a proposal of the European Council and more specifically of the Prime Minister, the Dutch Prime Minister Lubbers, in 1990, when at a meeting of the European Council in Dublin, came up with the idea of establishing a European energy network. And from this was I would say, a short leap to developing the European Energy Charter, which was basically a collection of great ideas, but also the important start for the negotiation of the Energy Charter Treaty. And as it started as a European idea, of course, the focus was to bridge the East and West. And of course, political reasons attracted Canada and Japan and US and Australia at the negotiation table, but this is probably for another panel. So I would say that in the making, the Energy Charter Treaty became a true multilateral treaty. And let's not forget that some of the European EU member states that are now contracting parties to the Energy Charter Treaty at that time were not members of the European Union. Romania, Bulgaria, and so on. So I would say that also from the perspective of being a multilateral treaty and how the treaties are being amended, the European Union is not in a very comfortable position. As a matter of fact, as I was mentioning, there is a strong opposition on various issues from the Central Asian states. And there is strong opposition from the some of the EU member states. For example, France is probably the most vocal, adding to that Germany. As far as I know, Austria is of a view that the Energy Charter Treaty should continue. So I don't think at the table we have a real consensus. And in this way, also we have to think of the European Union position on the energy market. As we know, throughout the years, the import dependency of the European Union was and continues to be a real issue. In terms of the climate change, I think everybody has more or less the same goals. And this is because of the international commitments. I think it's a very interesting balancing exercise, the modernization process. There are clear goals to be achieved. And this is why the Achmea issue, to go back to Alessandro's presentation, was left at the end, because there are more important issues to deal with first. The Achmea may be dealt, as it was mentioned, within the Court of Justice of the European Union. I don't think there is a real problem. I think the real problem is to manage to achieve a comfortable outcome for all the contracting parties involved.
Thank you so much, Karina. And now, without further ado, let's go to Markus Gehring. Markus Gehring is going to talk to us about how the EU is mainstreaming climate protection and sustainability in its trade and investment agreements. He's the incoming director of the Center for European Legal Studies, a fellow and director of studies in law at Hughes Hall, and a fellow at the Lauterpacht Center for International Law at the University of Cambridge. Markus, you have the floor.
Thank you very much, Ilaria, and it's a great pleasure to be at SIEL and to be part of this panel. So I will broaden a little bit the perspective and briefly talk about climate change and the green economy, border carbon adjustments, innovations in modern EU FTAs and IIAs, and offer some brief conclusions. Taking a step back, I think we need to ensure that trade and investment is aligned with the green economy objectives, with the Sustainable Development Goals. We all know in this conference that trade and investment environment don't have a black and white relationship. They're much more shades of gray. And these are not really sort of just theoretical questions. Practical disputes have arisen in the field. Now, the EU as a trading bloc has very ambitious goals, especially the EU's climate ambition for 2030 and 2050 is trailblazing in the world. And so it's only right that some of these ambitions have to be reflected in the trade and investment policy, in the trade and investment lawmaking. I should highlight that some of my research is drawing from our book, and my publisher always says, mention the book, Sustainable Development in World Investment Law. Moving a little bit to the trade side, I think border carbon adjustments are going to be a big trade issue. There might be some minor investment aspects as well. The sort of issue of what is the exact nature of carbon allowances. If I'm invested a lot of money into these carbon allowances, is that a protected investment, etc.? But the main concerns will play out on the trade field, and we just had the ad hoc discussion over lunch as to how the leak of the CBAM proposal aligns with trade law, with WTO law and regional trade law. If I could offer my own opinion, I think it's perfectly in line with WTO law. I do think it raises some concerns with regards to bilateral and regional trade deals that the EU has concluded, but as so often, the devil's in the details. And just to summarize, at the moment, the favorite model by the Commission that the Commission will propose hopefully next week is to surrender notional EU allowances upon importation. And of course, if there's still free allocation of allowances, that would indeed perhaps create WTO concerns. That's why the EU Parliament, in its opinion, urged the Commission to phase out these allowances. Now, innovations in EU trade deals, and I only have time to share very few, but I wanted to highlight particularly the climate innovations. And we did a broader study when we last year analyzed what are the potential options, how does the EU proposal align with the UK proposal, especially in an UK-EU trade agreement post-Brexit. And what we didn't expect in our wildest dream was what the TCA finally contained. But I'll get to that in a second. We highlighted innovations, for example, EU-Japan. EU-Japan doesn't contain any investment law, not much to speak of, but is the first trade agreement by the EU that affirms commitments to effectively implement the UNFCCC and the Paris Agreement. And I think that choice of language, not just affirming commitment under the Paris Agreement, but to implement the Paris Agreement is particularly strong and is replicated in other provisions. The agreements before that, EU-Singapore and CETA, the EU-Canada agreement, don't contain the same level of commitment. Indeed, they are much less strong when it comes to committing to compliance with international agreements such as the Paris Agreement. But they're much stronger than the US approach. If we look at USMCA 2018, it just recognizes the important roles of international and multilateral environmental agreements. Now, the UK-EU TCA doesn't contain much of investment law to speak of, also because it's an EU-only agreement, but it contains the strongest protections in any trade agreement with regards to climate change. Climate change becomes a material breach issues. Article 764 declares the fight against climate change as one of the bases for cooperation alongside democracy, rule of law, human rights, and non-proliferation of weapons of mass destruction. It's one of the strongest language found in any trade agreement, declaring climate change represents an existential threat to humanity. There's a separate definition of the climate level of protection, and it is somewhat lower than the current NDCs of either the UK or the European Union, but nonetheless, it links it to a trade agreement. Neither of these definitions reflect the new ambition. But Article 392 obligates the parties to have in place an effective system of carbon pricing, and this again contains one of the strictest formulations of any non-regression provisions. Finally, to investment law. And I know in this conference we discussed a lot that the EU-China CAI is actually doomed and will never enter into force as it is. That might be the case, but from a sustainable development environment perspective, again, it's one of the strongest investment agreements that we have, because, for example, in Article 6 of the Sustainable Development, Draft Sustainable Development chapter, the parties shall effectively implement the UNFCCC, the Paris Agreement, including its commitment with regards to national determined contribution. And that is not found in any trade or investment agreement. So what are my conclusions then? The EU Green Deal clearly requires flanking measures in trade and investment agreements. CBAM will not be popular with trading partners, but if carefully drafted, in my view, does not raise any WTO concerns. The TCA is currently the furthest developed, but it is expected that all EU trade agreements will include much stronger climate and sustainable development provisions. And while expert processes are qualitatively different from trade and arbitration. These processes can provide powerful incentive for all actors, and you will forgive the academic in me that I would advise further research on the interaction between domestic climate measures and trade and investment rules is strongly advised. Thank you very much.
Great, thank you so much, Markus. And I think your last point is very important, right? I think the EU is doing a big effort for seeking coherence between its internal climate and energy objectives and its external trade policy. Have clearly showed how many innovations we can see in the latest generation PDAs. I was wondering whether you could elaborate a little bit more on the investment side. I mean, you did talk about the PI, but maybe there's some further reflection you want to offer us?
Yeah, I personally, I would love it if we had a model BIT coming from the European Union. We have proposals, of course, by the German government, by the Dutch government, how that could look like. But I think it's expected that the sustainable development chapters that we've seen all over the FTAs of the EU, plus the expert process, so not submitting the Sustainable Development Chapter necessarily to the ISDS, Investor State Dispute Settlement, but rather having a separate process is going to be what the EU will put on the table now with all trading partners, in addition, of course, to the investment court system and this kind of entire elaboration. And I note that in the investment court system, the EU now insists not just on expertise in international law, international economic law, but also on expertise in international environmental law. And I think that is the way to go about when we're trying to analyze these disputes, which can be very technical indeed. It's not easy to solve these disputes, but as we've seen with the EU-Korea FTA, even though the expert process is said to have no teeth and will be ignored by the trading partners, the reputational damage of being on the receiving end of a negative expert opinion is so strong that it will have political implication for the trading or investment partner countries. And I think that's, on the whole, that is good news. Take a really close look at the CAI, because I think the CAI, even though the circumstances are particular, contains on the sustainable development and climate change side quite a few of the provisions that we would expect in all EU BITs.
Thank you so much, Markus. I would have many follow-up questions, but in the interest of time, let's move without further ado to introducing the first speaker, who's Andreas Hösli. He's a PhD candidate at the University of Zurich and a visiting researcher at the Center for International Law and Governance at the University of Copenhagen. And he's gonna talk about how to reconcile environmental protection in the recovery, focusing on sustainable corporate governance. Andreas, you have the floor.
Thank you very much for the kind introduction. I'm doing the usual technical stuff here. I hope everything works fine. I'm trying to stick to the time. I don't want to get a red card. Coming from Switzerland, we have very bad experiences with red cards recently, so I don't want to repeat that. What I'm trying to do here is to add another perspective to the broader discussion and trying to explain you a little bit how all of this links to the Commission's initiative on sustainable corporate governance. So how does this connect with each other? Here's some quotes I found in important documents from the Commission. if you maybe look at the first one in the Green Deal, it was said that sustainability should be further embedded into the corporate governance framework, as many companies still focus too much on short-term financial performance compared to their long-term development and sustainability aspects. So there you already see a bit in which direction this goes. And then in a later document of May 2020, the next gen document, it was said that at least 1.5 trillion euros of additional public and private investment will be required in 21 and 22 to get Europe on the road to a sustainable recovery, whatever that exactly means. And then lastly, I want to highlight another quote, which says that to help unlock the private investment, and I think we mostly speak about private investment here, long-term certainty and predictability are essential. To ensure environmental and social interests are fully embedded into business strategies, the Commission will put forward a new initiative in 21 on sustainable corporate governance. So that's where we are. One step back, what are the broadly acknowledged problems of business as usual? We have a tendency to short-termism given pressures in the markets. There is also the notion of shareholder primacy, which is very strong. We may have questions with regard to which incentives there are in relation to board remuneration. Some argue that directors' duties are not strongly enforced, and there are questions relating to whether there is sufficient sustainability expertise at board level. You may, of course, question any of these points, and as a very basic question that I'm leaving open here, please define sustainability. So this brings us to a status quo where we have basically only reporting obligations for corporations, for large corporations in the EU. And at the bottom line is that human rights and environmental issues, such as climate change, biodiversity, etc., are still in 21 externalities largely left to the public sphere to deal with, which led to a call for EU policy intervention. And then on top of this, we had a virus, as you all know, from 2020 to however long this will last. So this brings me already to the last slide. What is the Commission doing with this? They commissioned a report which was written by Ernst & Young, published in 2020. And based on that report, they made a public consultation, which has just been concluded. And I found that these 5 points that I highlighted here are the main, measures that are being considered. And I'm going to go briefly through them. The first one is clarifying directors' duty of care. So what this means is all of these measures, most of the other ones as well, really focus on decision-making by the corporate board. So in this specific first point, it is considered whether a wider range of stakeholders and not only shareholders should be considered by directors in their decision-making, and whether or how these duties should align with the long-term interests of the company as opposed to the short-term interests of shareholders. Then it is being discussed whether enforcement of directors' duties should be strengthened. Remember that one criticism is that for various reasons, this is not the case today, meaning that directors are strongly protected from enforcement, not least by the business judgment rule, which restricts courts in looking at, in hindsight, at business decisions taken. And this may mean, or it is discussed, whether there should be an enforcement role for civil society stakeholders, which is obviously something completely new to corporate law, where you would normally only have such an enforcement role for shareholders, or for creditors in a case of bankruptcy. Then the third point is that's remuneration of directors. So should they be tied to non-financial performance? For instance, greenhouse gas emission reductions. So should there be a greenhouse gas reduction target for a company, let's say minus 45% until 2030? And should that be tied to the remuneration? The fourth one is also a very important one. This concerns supply chain due diligence, not only human rights, but also environmental and also specifically climate change. Many questions there as well relating to coverage. So what's covered? Which areas are covered? Should we make specific silos? Or would we prefer a sustainability due diligence that covers everything? And other key unresolved questions concern liability. So how would due diligence translate to liability, if at all, etc. The last one I want to highlight is sustainability expertise of the board. You may have heard from other areas, gender, etc. Should there be quota, or should there possibly be regular assessments by an external expert? Yes, so these points I want to highlight. We are now at the very early stage of this project. As I mentioned, the public consultation has just been concluded, and the project has also been a bit delayed. So coming back to transparency, currently it's not very transparent where the process is, but it is expected that we hear very soon from the Commission what the next steps are. With that, thank you very much, and looking forward to the discussion.
Thank you so much, Andreas, for this presentation, which I think highlights some of the most interesting innovations, perhaps to be incorporated into these proposals, but also the many question marks that are still pending. So to me, being based in Switzerland, of course, I thought about the Swiss Initiative for Responsible Multinationals, which just failed last year. But I just wanted to ask you, I mean, what do you see as the main, perhaps, limitations in the current, based on the current information that we have, and the main actually interesting innovations that could be perhaps also serve as a blueprint for future legislative developments also outside the EU, if you see any?
Thank you. Yeah, for me it's very difficult to say, given that we're still at the very early stage. I think we will be able to say more once the consultation process has been summarized by the Commission and with results. Overall, I'm not overly optimistic. I found it a bit questionable why a report was commissioned by EY, and then the Commission just used that report to follow up with the next steps, but that's only a side remark. Overall, the potential role model would obviously be the GDPR, so the data protection regulation, where the EU has sort of set a global standard. But I feel with sustainability, it's a bit more complicated because of all the factors that make it complicated. Not least, obviously, strong opposition by businesses and states to really take the meaningful steps that are arguably necessary, and also that we have a collective action problem, which is different from data protection, I would say. Where I do see potential is to really look closely at the concrete measures proposed or considered by the Commission, but I think there a lot of thinking still needs to be done to get a lot more clarity what it actually entails. This is probably where the consultation will advance the discussion. but I think a lot needs to be done. And then in the end, yes, generally that could be used by other areas in the world as well. But it still really remains to be seen because we're at such an early stage.
Much, Andrea. Now I see we already have quite some questions in the public chat. I also would like to remind you before giving the floor to our speakers that there's also the Q&A function in case you would like to raise your question directly. But in the meantime, perhaps we can start. I have a question for Matteo and Alessandro from Wojciech, who asks whether you think that a hypothetical decision by the Court of Justice of the European Union, which excludes ISDS under the ECT to intra-EU disputes, would effectively block such disputes, considering the approach of tribunals to Achmeas that have been following that judgment. Who would like to take the question? Alessandro, please.
Thank you, Ilaria, and thank you, Wojciech, for the question. And well, I agree with you that the arbitral tribunals would probably continue on the line of jurisprudence, which largely disregards to an extent whatever is decided by the European Court of Justice. And this we have seen at least with Achmea, and a potential ruling in the Athena versus Italy case would probably lead to the same consequences. But as I highlighted in my presentation, I believe that potentially there could be implications when we're talking about annulment of awards, because if these are adjudicated by European domestic courts, then these would be bound by the CJEU rulings, and so they would need to follow up on those decisions. And the same also if investors need to act against states for the enforcement of the awards. So I think this could be the more practical implications of a judgment by the European Court of Justice.
Perfect. Thank you so much, Alessandro. Then I have a question for Krina, who's also posed by Wojciech, that basically asks whether you see whether there is a risk that even if the Energy Charter Treaty is reformed to extensively embrace environmental obligations of the host states, the arbitral tribunal would anyways decide against the host state, either because of being locked in the previous investment jurisprudence, or because of the inconsistent practice of proportionality tests, or because of the survival of the object and purpose of the Energy Charter Treaty as to protect investment no matter what?
Very interesting question. I would say that of course tribunals have the discretion. They have to interpret the treaty first of all, and they also have a specific set of facts they have to work with. And I think this is highly relevant when one reads the outcome of an investment arbitration case. Never the factual background, and of course the fact that tribunals are not bound by previous tribunals' decisions, and they have to conduct their own exercise to interpret the treaty. Now, if we think that new Energy Charter, let's assume that the new provisions are adopted in the form as they are proposed now. As I was mentioning, there is no spelled out test to assess whether the state exercised the right to regulate in accordance with the treaty. And the various tribunals, obviously, in the past as well, and under the Energy Charter Treaty, they expressly said that while the right to regulate is a right recognized under customary international law, this right has to be exercised accordingly and is not unlimited. I think the problem with the right to regulate and how the tribunals would assess this, the police powers of the state, the issue comes from the burden of proof more than how the tribunal would conduct this assessment. because it's highly relevant who starts first, I would say. And in the recent years, we've seen a recent case that I would recommend a thorough reading is the Laborator Servier against Poland, where the tribunal took a kind of a midway approach. Well, the investors said, well, the respondent, Poland, has the burden to prove that the measures it took are within the right to regulate, so as an affirmative defense. Obviously, respondent, the state Poland, said that it has only a prima facie burden of proof, and then the investor is the one that has to demonstrate that those measures were in breach of the treaty. And the tribunal said, well, let's meet midway, and it took from both approaches, and it basically said, well, the state has to give a prima facie proof, and then the investor obviously has to come and rebut that, and so on and so forth. So I think the problem that I will see in the future is more on tribunals having to deal with this highly procedural but very relevant questions when it comes to the right to regulate. Thank you.
Thank you so much. I'm going in order here. I see there are also a few questions for Markus. To a certain extent, he's already provided the written answers, but perhaps you want to also share with the audience his answers. Well, we had a question on the enforceability of environmental commitments in trade agreements, and also a question concerning the value of panel experts' reports. Markus.
Yes, let me address the question by Professor Batens first. She is, of course, right. An FTA panel will not be as effective as a WTO panel. A WTO panel will not be as effective as an appellate body decision if we ever have one again. So there are different grades of how effective some of these positions and provisions can be. But I think we shouldn't underestimate that great reputational damage could be inflicted by a profoundly negative expert opinion. Now, the first attempt at this in Ukraine went horribly wrong, arguably, for the EU. But the second expert opinion in Korea, I would argue, was a win for international labor rights and enforcement of those rights, with the Korean parliament immediately moving to the ratification of the missing conventions, even though you would argue it was just an expert panel report. We did quite a bit of research on the citizen submission process under the NAFTA CEC, the SEM process, which, by the way, has been preserved in USMCA, NAFTA 2.0, and which has proven to be quite important where a report was agreed. It wasn't as effective if the report was vetoed by one of the parties. And I think that's also an important lesson. Now, it wasn't an arbitration process. It was investigated by the CEC Secretariat, but nonetheless, it shares some of the sort of expert panel characteristics. And make no mistakes, I think we will see many more expert panels. I think the EU is getting a taste of using this sort of somewhat hidden tool. And I wouldn't be surprised if we saw also greater reaction then in how trade relations are conducted going forward based on an expert panel. So there could always be unilateral measures, as are already built into the TCA, but could potentially be built in to more EU trade agreements. Yes, so I think with regards to the Yeah, I think the controversy about ISDS is also not going to go away, right? So we sometimes think ISDS is the sort of gold standard of all investment disputes. I think that entire instrument is called into question to a certain degree, and rightly so.
Perfect. Thank you so much for this comprehensive answer. Markus, I think I would then go to Andreas, who's also received the question, which I had just here, from Nazlici Tech. So, Andreas, do you think the lawsuits brought by shareholders of major fossil fuel emitters to unset board members for not adopting climate change compatible strategies have the potential to increase the taking up of environmentally friendly policies on the part of the corporation in the longer term?
A very good question, and my answer is yes, absolutely. Litigation is, if you will, the most direct way to achieve a goal if you just can't get there else in another way. And I believe that 21 is really, or appears to me that it could be really the year where we see major first cases. Think of the Shell case in the Netherlands. And it's incredible that a major oil company is ordered by a court to reduce its emissions by almost half until 2030. That would have never been possible 5 years ago, I would say. And why is that? Because the people are alarmed and climate science advances, and this increases every year. And at some point, even if the law is the same, this has an impact on courts, where they will take account of what's happening in the world and in science. And as you mentioned, a very important point is that investors acknowledge the problem. Climate change is now recognized as a financial risk, and especially institutional investors are taking action now, as the case you mentioned in your question shows. So absolutely, I believe this is something to follow.
Thank you so much, Andreas. We've had also like a couple of more general questions addressed to all panelists. So perhaps what I thought in the last couple of minutes that remain is to address them to the broader group, and then we can have a tour de table with your final remarks addressing whatever question you feel you want to answer to. So the first question is concerns the modernization process of the ECTs and the conclusion of greening treaties. And it is asked whether you think that these two parallel processes may fail to achieve the objectives because of MFN, and if so, how to deal with the issue. Then another question is whether you think that recent trends in favor of sustainable development and climate mitigations in new free trade agreements, the EU Green Deal and the modernization of the Energy Charter would have an impact on the tribunals that are currently deciding the renewable energy cases under ISDS to favor renewable energy investors, and whether they would de facto restrict the state's rights to regulate as an effect. And then the last question also concerns renewable energy, and in particular renewable energy support schemes, and basically ask whether, in light of the recent renewable energy incentivization scheme, the BAC, whether you think investors will or should be willing to get on board with any further incentivization schemes, and what could states do to repair the trust. So I think we could go perhaps in reverse order and start with Andreas. If there's any point you would like to address.
No, I pass this on.
Okay, so then Markus, I think there was quite some material for you to cover.
Yeah, I'm always happy to cover materials. Unlike many of my environmental law friends, I don't actually think the solar panel cases in any way undermine the investment law regime. I think the opposite is true. It highlights the fact that investment law is not just for dirty old industries. It's also for new movers, first movers, who have precious economic operations that could be wiped out by one stroke of a pen by a government. So I think it, in many ways, underlines the need for investment law and effective investment law enforcement. And therefore, I think I always counsel my environmental friends to be careful what they wish for, because at the moment, large petrochemical or fossil fuel companies have many other measures to protect their investments. It's small and medium-sized renewable energy companies that are going out on a limb and could be in danger of losing everything if the country suddenly changes the regulatory frameworks, especially with regards to these support schemes. I think, yes, sort of ideally, we have a system that takes sustainable development very seriously. And I already highlighted that I regard the TCA probably at the edge of the outer limit of what is possible in a bilateral trade agreement. Take a good look at those provisions, because I don't think they're going to go away. I think some trading blocs, trading partners will take inspiration from what the EU has agreed. The EU itself considers the TCA a complete outlier and not really relevant for its treaty practice. But I would argue it's a treaty on the books that we need to have regard for and analyze very carefully as researchers.
Absolutely, couldn't agree more. Then I go to Krina.
I would just add some. I completely agree with Markus on the ISDS and the fact that the negative outcomes would be felt tremendously by the small, medium, or even MSMEs and individuals. If you look at the statistics for the Energy Charter Treaty arbitrations, last year, the Energy Charter Secretariat has published a very interesting statistics, 134 cases. 58% of these cases, a very good number, investors were SMEs, and 12% were individuals. So we have more than enough arguments to say that it is not only for the big companies, it's actually more for those who actually need it. And as Markus was saying, big companies will always have the bilateral arrangements, and those bilateral arrangements come with less transparency than an investment treaty. So probably we need to pick our battles here. On the question of MFN, I think this is a very interesting aspect and probably topic for an entirely panel on the topic. But the most favored nation treatment clause is actually going to have some redrafting in the new version of the Energy Charter Treaty. And this relates directly with the question asked, because there are two, in general, tribunals will have two positions on the MFN clause. One that takes the MFN clause as allowing the importation of a more favorable treaty, more favorable provisions from other treaties with third states. And the second approach, which it puts the tribunal to make an actual assessment of a de facto situation of the investor, because most of the treaty will refer to in like situations or in like circumstances. So it's not something that has to be measured in abstract, but something that has to be viewed in the specific case of the investor. The Energy Charter Treaty, as probably will exclude the first interpretation, the one that tribunals will look into abstract and will allow the cherry picking from other treaties. And I can see the trend nowadays is also in this direction in general in investment arbitration. So I think there is not really a big concern from this point of view. The MFN clause has its own purpose in any investment treaty, and obviously it served very well in the past. Thank you, Ilaria.
Great, thank you so much, Krina. Last but not least, Alessandro and or Matteo, briefly, if you want to address any of the points that were raised in the questions.
If I may, Ilaria, I will throw a lifeline to Markus. He mentioned his friends, environmental law friends, and this reminded me of some discussions I had exactly on the same point, exactly amidst a lot of environmental lawyers who were like kind of picturing investors in investor state arbitrator like creeping guys, just craving for smashing down host states environmental regulations, right? And that was like, take a step back. Investor states arbitration serves another purpose, and perhaps host states should think twice over their behavior, especially Italy and Spain, right? And how they put forward some over-remunerative schemes and how they, let's say, miscalculated in advance before attracting a lot of investments. And that also draws back to Freya's point on whether they should do something to rebuild the trust towards future support schemes for renewable energy. In the meantime, Ilaria has dropped out. But I do see, Markus, the point of also intellectually, let's say, mutually understand what these two different fields of law, and I would say different words, have to communicate in order to mutually reinforce each other. I do agree, and I do believe, first, that ISDS is not going to leave, is going to stay. And this draws back to another question. I don't think ISDS is going to go anywhere. Anywhere outside the EU. The EU is going to face other inter-investment disputes. I think also the other developments about Achmea are being downturned by ISDS arbitral tribunals, and this will be so pretty much so until the ECT will be reformed in whatever way. So the need is to ensure that member states just do things right in order to both ensure protection and predictability for investors and pursue ambitious goals. And this is the whole point of getting everything done in the right order, so to speak, I think. And that's on your point, Markus, on further research on climate policies and investment law. I would like to mention that this project that I have started together with some colleagues at LSE, Grantham Research Institute, and Xavier Center for Climate Change Law. We are now mapping out all climate-related ISDS disputes. We have tried to come up with a taxonomy of what a climate-related ISDS dispute is, mostly focusing on 3 points. So on rollbacks or abrupt changes to regulatory environment related to energy investments, permitting litigation, so litigation related to permitting of infrastructures. Think of the Ixal pipeline case, which is now being revived, as far as I understand. And last, more generally, let's say, policies that are justified under climate grounds that somehow impinge on, more specifically, fossil fuel assets. So just think of the RWE case, for instance. These are the 3, let's say, umbrellas under which we are trying to investigate the ISDS cases, although we all know that each case is kind of universal on its own. But I do agree that further research is needed, and I think also there are a lot of developments in that direction too. So, well, I think Alessandro would like to add anything, because I'm now, I think, turning my head to moderator once again. So, Alessandro, if you want to add anything.
Thank you, Matteo. Somehow, whenever it's my turn, Ilaria disappears. I don't know if it's related, but yeah, I wouldn't add much because much has been said already. So just on your last point, perhaps, that I also share the view that ISDS in itself is going to stay, at least in some form, and also that I would consider it as a rather neutral instrument. So I don't think it's so much ISDS being the problem, although, of course, transparency could be improved and so on. But it's rather the substantive standards in the investment treaties that need to be more directly addressing climate change. And in this regard, when Krina was mentioning the modernized draft of the Energy Charter Treaty, referring to the Paris Agreement, I think this could also be at risk of becoming a bit of greenwashing sometimes, because often many treaties just refer to environmental climate agreements, but what does it even really mean to recall the Paris Agreement, and which of the temperature goals, and does it include the NDCs or not? So it would open the door to many other considerations. I think instead what Markus was telling us about is very interesting. For instance, in the EU-UK treaty, having substantive standards and considering climate change as a material breach, I think this could be the way forward, perhaps, but it's also very, I think, long and winding road. But yeah, it is, by the way, also what I'm going to analyze in my postdoc project at the University of Copenhagen, which is all about the interaction between climate change law and international investment agreements. So I hope throughout the next years to also find some potential ways in which investment law can further support climate action. And this is all from my side. So I think I will give the word back to the moderator ad interim, Matteo, for some final remarks.
Well, always glad to take over. I mean, in theory, we still have some 3 minutes or 2 minutes and a half left to cover our 90 minutes slot. But I understand also participants would like to switch to other rooms. The program is pretty packed. So I don't know if any of you speakers have further remarks before I wrap up the whole panel, unless Ilaria shows up immediately. I think we have addressed pretty much all the questions. We have some question marks still. I mean, we have still a lot of blind spots, I think, highlighted in this panel that have to be addressed. So I wish to thank you all for the presentations. If there are no further comments, Markus, Krina, Andreas.
Just to thank Ilaria in absentia very much for chairing so well. She herself has contributed so much to this debate, and I would urge all the participants to look up the fantastic research that Ilaria herself is also doing. And just to end with an invitation, the University of Cambridge is organizing a big climate law and governance conference on the last weekend of October, just before the Glasgow COP. It will be hybrid, in person and virtual, and there will be several economic law and climate change panels. Thank you, Matteo.
Thank you very much.
Yeah, thanks a lot, Markus, for thanking Ilaria. I was about to do that, of course, for steering that and for the work she has been doing. And we are now also doing together on this. I think there must be quite an effort from the academic world to really disentangle some issues with regard to the development in the climate change arena and the investment law arena. So once again, my turn to thank all of you. Thank all to the participants for listening and for their questions. We are here. We can reach bilaterally for any follow-up. And I think I can now wrap up somehow this meeting, although I'm not in charge of it. But thank you all, and see you next time, or see you in other breaking out rooms at SIEL. Thank you very much.
Thank you very much. Thank you. Goodbye.
Bye-bye.
Okay,
thank you,
Markus.
Matteo. That went really well.
That went well somehow.